Okay, welcome everybody. It's just gone past 11, so we'll start. Latecomers, no doubt, can log on at their will. Thank you very much for coming to this webinar. This webinar is called 6 Secret Solutions to Every Boardroom Dispute. Are we going to set out all the ways in which you can have a boardroom dispute? No, we're not. There are as many possible disputes as there are people in the world, I think. What we're going to do is we're going to look at a specific scenario. We're going to look at private limited companies, the rights and responsibilities of majority shareholders, and what to do if there is a fellow director shareholder who is undermining the business, competing with the business generally, lying to you, ripping you off. My hope is that by giving you that information, we will touch on all the things that you need to think about in any given boardroom dispute, and that you can extrapolate that information to your own situation if you're facing one, or if you know somebody who's facing something similar. If that doesn't work, please do let me know, and we'll try a different approach. But I'm pretty sure we've run this a few times now, and it seems to work quite well. My name is Christopher Bergen. I own and run Christopher Bergen Solicitors. We are a specialist litigation and commercial law firm based in central London. I've been a solicitor for 23 years. I've been working for myself for 12. During that period, I'm very proud to say that every case that we've issued on behalf of our clients have either won that case at a trial or they have settled in their favour. I'm helped today by a few people, so I'd like to introduce Elle Barrett. Hi, Elle. Elle is a specialist company commercial solicitor who works with the firm, and we'll be hearing from her later on. We also have Karen, who helps me run the firm. Hi, Karen. She helped me run the firm, and she'll be helping me with this webinar as well. And we also have Camilla. Camilla Laxton is a client of ours. And towards the end of the webinar, she will be giving you some real life frontline experience of matters like this. So let's get going. Firstly, let's look at what are the 6 steps. I'll run through them pretty quickly. First one is the psychology of disputes. That's the first thing I'm going to talk about. So just here, I'll say it's very important. We'll go on to that soon. Next one is who holds the power in limited companies. We'll have a discussion about who runs companies, is it directors, shareholders, what level of shareholding you need. Number 3, getting the problem out of the business. I'm going to try and convince you that if somebody is in your business and they're ripping you off, working against the interests of the business, then you should fire them. And I'll give you some details on how to do that. Do you need an injunction? That's about protecting the business. I'll talk you through the process of injunction, what you need to get one, whether or not it's something that's going to be right for you in your dispute. Recovering losses. If somebody's cheating you, ripping you off, you're going to be incurring losses. We'll talk about if it's going to be worth bringing a court case to recover those losses. And the last one there, number 6, getting your shares back. Isn't it galling that if somebody's actually actively ripping you off, working against your interests of your company, you can get rid of them, you can fire them, but still they will have shares in your company and they will be profiting from the future success of your company. So we will deal there with how to avoid that most unsatisfactory of situations. Okay, so here's the first one, the psychology of disputes. We've got a quote from Joseph Heller there, because this is all about your own state of mind. What kind of state of mind will you be in if you're faced with a dispute within your company? Well, your first reaction might be to deny that there's any kind of problem. Let's think about some scenarios. Let's think about somebody who turns every boardroom meeting into a massive argument and somehow gets their way because they intimidate and rage at everybody else. Or somebody who's, say, a bit more subtle, who is sending emails and basically building up their position in the company and getting more and more of the profit of the company for themselves. Or let's think of a third scenario, somebody who's simply taking money out of the business without your consent. If you've got one of three reactions to a situation like that, if you are pretending it's not happening, just dealing with the bad behavior and just trying to work your way through it. If you're making excuses for the bad behavior, saying, well, they're shouting, but they're under stress, or well, they do a lot of money, they do a lot of work for the company, so they're entitled to take the money, even if I haven't agreed to it. Or if the third thing that you're doing is actually convincing yourself that it's a good thing, rationalizing things. Yeah, we shout at meetings, but we get through the agenda pretty quickly. Or yeah, he or she is taking the money, but at least they're keeping that on board. If you're doing one of those three things, ignoring it, excusing it, rationalizing it, then you may well be in a state of denial. If you're not in a state of denial, then you face a lot of pretty difficult emotions. There's bound to be hurt feelings in there somewhere. Sadness, anger, hurt feelings, because we go into business with the people we like the most, our friends and family, people we trust the most. If that trust is broken, then we're going to feel really pretty hurt about it. We're also going to feel pretty scared and pretty anxious. I think nearly everybody I've met really hates the thought of being in a conflict with somebody close to them. If that person is aggressive, or if they're kind of a bullying, manipulative person, then that's going to add extra layers of fear and anxiety onto it. I had a chap came into the office about 10 years ago now, very intelligent chap, had McKinsey on his CV, told me a story about how his business partner ripped him off for about £500,000 and was in tears when he told about the effect it had had on his family. But at the end of the meeting, he said, I'm going to give him one more chance. He was so desperate to avoid conflict. What you also might experience in dealing with these disputes is massive self-doubt. We tend to beat ourselves up all the time. How did we get to this situation? Only I could be this stupid. We do it to ourselves all the time. I had a client, we got rid of her. She had a business partner, which she wanted us to get rid of, and we did so successfully. But at the time, she was saying, I can't believe I trusted this person. Only I would trust this person. And there you go. It's all pretty difficult stuff, I'm afraid. You may be in a state of denial. If you're not in a state of denial, you're going to feel pretty hurt. You're going to feel pretty fearful and anxious. Maybe you're going to suffer from quite a lot of self-doubt. If you can be aware of all these things, it's natural to feel all these things. If you're just aware of them, but not act on them, and instead maintain a positive, rational state of mind, you're going to be in a really strong place. I'd like to tell you about a case study that we're going to run. Clearco is the name of the company. It's on the company website if you'd like to look at it in more detail. Tom set up Clearco as a construction business. They're doing ever so well, and he needed some marketing help. So he went to his friend, Anthony, to do the marketing for him, and he gave away 30% of his shares to Anthony to carry out the marketing. Anthony, over time, kept asking for more and more money, and eventually came to Tom and said, okay, I've built this mirror website, a website exactly like yours, just slightly different. And if you don't give me 50% of the company, I'm going to start competing against you. I have to say that was a bit of a shock for Tom at that point. Obviously, a lot of emotions involved, but I think Tom dealt with that really pretty well, and I'll explain more about that later as we go along. Okay, so that's the psychology of disputes. Let's deal with something a bit more easier, which is company law. Who holds the power in a private limited company? Let's just go back to the basics. The law regards a company as a separate entity to the people within it. So, and because it's a separate entity from the people in it, it has its own constitution. Now, that will be the Articles of Association applied to the Companies Act, which also affects it. And there may be a shareholders agreement, may be director service contracts. That is the company's constitution. Here, I'll talk about the model Articles of Association, which is what most people adopt when they open up a company, when they start a business. Nothing wrong with that. I myself adopted the model Articles of Association. What do they say about who's in charge of the company. Well, Part 2, Section 3 of the model articles says that the directors are responsible for the management of the company. Part 2, Section 4, though, says that shareholders can make directors do anything they want. They can completely overrule directors if they pass a special resolution. The Companies Act says that you need 75% to pass a special resolution. So if you are in control of more than 75% of the shares of a company, then you will be in control of it. Doesn't matter what the directors are saying. I had a client, a different construction company, on the eve of lockdown back in 2020. There were 5 directors in the business. He wanted to save the company. They wanted to line their own pockets. And they kept saying to him, we're going to outvote you. We're 4-1 on the board of directors. We're outvoting you. You have to do what we say. He came to me. Actually, he held 80% of the shares of the company. And so he could ignore what they were saying and he could control the company, which is what he did. Okay, what if you're saying, I don't have 75% of the shares? Well, if you have 51% or more, which by definition is a majority of the shares, you still have a great deal of power because you can remove directors through a shareholders meeting. It just takes a majority of shareholders to remove a director. So if you have 51% or more, you still control the company. Right now, you'll know whether or not you are in control of a company. If you are, please don't do what one of my clients did in February last year, which was agreed to give away 26% of his shareholding. So he lost the power to pass a special resolution and sign up to a shareholders agreement, which gave away his right to remove directors. In one fell swoop, he'd given away all of the power he had over his company. What about our case study? Should Tom have given away 30% of his shares? Well, to me, it seemed unwise. As it happened, because Tom was the only director, he didn't really lose power over the company. But if he wasn't, if they were both directors, it would have been pretty unwise. What could Tom have done differently? He, of course, could have given away fewer shares. Alternatively, he could have set up a different class of shares, shares which say will pay a dividend, but which wouldn't have any voting rights. At that point, let's pause for a question. I would like this to be as interactive as possible. If you'd like to ask a question, please put it in the chat. That'll be viewable to everybody. You can also use the Q&A. The advantage of the Q&A is, if you like, it can be the question can be asked anonymously. For now, I'd like to ask Elle a question. Elle, are you there?
Yep. Hi, Chris.
Hi, Elle. So we've just been talking about control of the company and the constitution of the company. Can we use, my question to you is, can we use shareholder agreements as part of the constitution of the company to avoid disputes or at least to help resolve?
Completely, yes. And I would always argue that it's really important to make sure that you consider putting a shareholders agreement in place for all sorts of reasons, but mainly to try and prevent disputes occurring further down the line. I don't know if my connection's a bit dodgy. But what I would just do very quickly is I'm just going to highlight a couple of the key provisions that I would expect to see in a shareholders agreement. So the first one, and the reason why it's really, really important, is to make sure that there are clear decision-making structures and processes in place within the business, and that they are set out clearly within the framework of the shareholders agreement. Who can make decisions at board level, at shareholder level, who's able to veto those decisions, and such like, who should have the casting vote in the event of a deadlock. Another really, really crucial provision is how to value these shareholdings within the business. Unfortunately, I and Chris have seen too many times disputes as to the value of shares. For example, if a shareholder is exiting, how do we value the value of that exiting shareholder's shares? The shareholder agreement should contain a very clear mechanism upon which those shares should be valued. And finally, as Chris said, proper dispute resolution procedures should be in place so parties can follow the steps outlined in that shareholders agreement.
Okay, great. Thank you very much,
Chris.
Shel. Let's keep going. Okay, so now we're into the time to take action. We've got our mindset correct. We're resolved to take action despite all the difficult emotions. We know our place in the company. We know that we've got power. So let's say you've got the power in the company. What should you do with the person who's ripping you off, undermining the business, lying to you? I say, get them out of the business. Of course. Is it always that easy? No, it's not. We go into business with our friends and family. I was involved in a dispute a few years ago where 3 director shareholders were all brothers. One brother was clearly just in it for himself, just trying to line his own pockets still. I think the other 2 brothers found it very hard to kick him out of the business, understandably so. The person that you might want to get rid of might also be responsible for most of the profit of the business. They're the person that brings in the work or does the work. So you're thinking, if I get rid of them, I'm going to lose a big chunk of the income. That may well be the case, but I say to you, why on earth would you want to be in business with somebody who is fundamentally dishonest? And say, get them out of the business. If you're with me on that, let's look at the mechanics of it. So people within private limited companies can have up to 3 points of contact with that company. They can be shareholders, they can be directors, and they can be employees. Shareholders we'll deal with later at the end of the webinar. Directors, we've just said that you can remove a director if you control 51% or more of the shares. There is a slight caveat to that, in that if you're a small company and there's only 2 of you, the model articles say that a shareholders meeting can only pass resolutions if it has 2 people in it. If you're the only 2 shareholders and you want to remove the other person as a director, then if they don't turn up to the meeting, the resolution can't be passed. What you have to do then is hold 2 or 3 meetings, which they avoid or ignore. You can then go to the court to ask them to allow you to have a shareholders meeting with 1, which is just you. Removing somebody as a director can be done if you're a majority shareholder with that slight caveat. What about employees? Well, even if somebody has been obviously ripping off the company and they are to be dismissed on gross misconduct, they're clearly guilty of gross misconduct, you still have to go through the correct procedure to get rid of them. If you don't, they will have an action against the company. Even if you should follow up at correct procedures to avoid wrongful dismissal. If they've been there for more than 2 years, you have to give them a good reason to get rid of them in case it's unfair dismissal. And of course, there should never be a hint of discrimination in anything that you do. Take you back to the construction company. The board meeting at the board of 5 people. Our client getting outvoted 4-1. He dismissed all 4 of the other people, but he threw money at the problem. He paid them off in full, got rid of them. They still came after him, still issued actions against him. So you do have to be very careful. Okay. Do you need an injunction? What is an injunction? It's a way of protecting your company. You've done the right thing, you've got the troublemaker out of the business, and you've done everything that a reasonable person would do to protect the company. You've made sure that they're not part of the IT system anymore. You've told your employees what's going on, so they're not going to pass any information to them. But still, they're dishonest people. Let's face it, what they've already done is they've already downloaded all of your client database, all of your intellectual property. And so now, there they are. They're going to be trading against you, undermining your business. What do you need? You need an injunction. An injunction will refrain, will stop them from doing that. How do you get an injunction? Well, you go to court and you say to the court, look, I'm going to bring an action against this person. But before we get into that action, I would like you to give me an order that says that they can't use the confidential information or the intellectual property both that they've got. And the court will say, fine, you can have this. So what's not to like about an injunction? I have to say, at this point, that an injunction is a pretty big commitment. First thing is that you have to make the decision quickly, within days, possibly a couple of weeks, becoming aware that the person is acting against you. And if you're ready to make that decision, you have to say to the court, okay, I'm going to bring an action against this person to recover my damages, recover my losses. In the meantime, I want you to give us an injunction. What you'll do is you'll draft all the proceedings. You'll either not tell the other side, or you'll give them very late notice, and you'll go to the court and ask them to give you an interim injunction. And then the court, if they grant you the injunction, will then put a second hearing 10 days, a week or 10 days later, in which case the person on the end of the injunction will have a case to put their own argument. So that's a lot of work. It's done very intensively. It's going to cost a lot of money. I think it'll cost around about somewhere between £40,000 to £50,000 in costs. Bit more about injunctions. What else do you need to get an injunction? Well, you've told the court that you're going to bring an action against the other party. You have to show to the court that you have an arguable case. You don't have to show them that you're going to win, but you do have to show them that you have an arguable case. The stronger you can make your case, the more well disposed the court will be to you, though. You also have to show that in all the circumstances, granting an injunction is the right thing to do. This is what the court calls the balance of convenience test. Let me use an example to show what I mean by that. Quite recently, somebody went against my client and they said, falsely, I think, if you don't grant us this injunction, all of the data of our company will be lost. It'll be deleted. But if you do grant the injunction, we will get to keep all our data, and then the two parties can argue out about who's responsible. So the court looked at both parties, looked at all the circumstances, and decided, was it best to grant an injunction or not to grant an injunction? And in that case, under the false claim that all data would be deleted, all data would be deleted, the court decided to grant an injunction. Injunctions really, really very useful, but a big step to take. That's where your psychology comes on board. Are you really ready to make that decision? My experience is that people will go for injunctions and will incur the cost and put the effort in if they think that they really have to, if they think that not getting an injunction will mean the end of their business. What did Tom in Clearco do, our case study? Well, Tom actually didn't go for an injunction. When he was faced with the ultimatum from Anthony, I've got a website, I'm going to compete against you, give me 50% of the shares, he did fire him, but he didn't go for an injunction. Now, I think Tom's thinking at the time, we weren't representing him, but Tom's thinking at the time was, we're still friends, there's going to be some kind of amicable resolution to this. And he probably also underestimated Anthony's ability to trade against him. He thought that basically it was a bit of a try on, and that if it came to it, he could deal with the competition from Anthony. About a year later, Tom was very keen to get an injunction against Anthony to stop him trading, but by that point, he'd missed the chance to get an injunction by several months. Okay. More questions? We've just been speaking about injunctions and getting rid of people. Al, if I can ask you to come back in.
Yep.
The question this time, Al, is can we do anything prior to getting an injunction to protect our confidential information and or intellectual property?
Yeah, well, I think it's very important to consider that directors of the business should enter into what are termed directors' service contracts, which is another way of saying an employment contract effectively, or some sort of consultancy agreement, but crucially, where these contracts are used to protect the company's IP and confidentiality, trade secrets and such like. These are some of the key provisions that should always be contained in a director's service contract. in their employment contract. It's important to have one in place to cover the director's capacity as an employee, as a director, as their appointment is also governed by employment law provisions. They will be impeded from disclosing confidential information about the company, about the business, clients, supplier lists, and such like. And this will make it contractually binding on the director and or the employee director as well.
Okay, so if you put in restrictive covenants beforehand, that will provide you with some kind of protection.
Absolutely.
All right. Thank you very much, Al.
No problem.
Let's keep going. We're doing pretty well at this point. We're got our correct mindset. We're well in control of our emotions. So we've got the power in the company. We've got rid of the problem. And we've protected the business by possibly getting an injunction. We now have to decide if we're going to go ahead with an action to recover the losses which the other side have caused to our company. Now, there's a couple of very basic things which you need to consider. And here they are on the screen on the slide. First one is, can the other side actually pay you if you successfully pursue a court action against them? A judgment is a very useful thing. You can send round the bailiffs, you can freeze bank accounts, you can put a charge on property and ultimately get that property sold, you can put a charge on shares. You can do a lot of things with a judgment, but if the other side doesn't actually have any money to pay you, the judgment is just a piece of paper. I've had a couple of cases. One case, we got a judgment for £220,000 in our favour, and the other side paid up in a week. That was great. I think that was because the client, the opponent had a lot of money. I think it's because the client went up and shook his hand the day before we got judgment. So actually, after all the dispute, there was still some good feeling there. The alternative to that is we got a judgment against a business partner. Classic 50-50 situation. That business partner did everything that he could to avoid paying us. He transferred his house into his wife's name. His wife then sold the house. She was a US national, so she took the proceeds from the sale of the house, sent it over to the US. We made him bankrupt. We did everything we could to secure the funds. It added years and lots of costs to recovering the money. So, can the other side pay your costs? Very important. The other thing you need to think about, and it sounds obvious, is what are your prospects of success in pursuing this claim? Too often people get carried away in cases. There's a kind of exchange of correspondence between solicitors and they get very wound up about it. What you should really be doing is getting a dispassionate view of what a court case looks like, what you can actually achieve if you are successful in a court case, and what your prospects of success are. Depending on that advice, you can either pursue the case and negotiate hard, or you can put a premium on negotiating for a second. What kind of court cases are we talking about? Being a director of a company, it's a pretty onerous place to be, actually, because there's plenty of obligations to it. In this scenario where the director's competing against the company, then they will be in breach of their director's duties. Director's duties are set out in the Companies Act 2006. I think the big three for me are that a director must work for the success of the company and all of its shareholders. He or she must act with due skill, care, and diligence, and they must disclose any conflicts of interest. I think between the three of them, that would capture any director that's basically looking to line their own pockets, without really fulfilling their obligations to the company. What if they're not a director? If they're not a director, then if they're involved intimately in the running of the company, then it's likely that they will have fiduciary duties. I've set out fiduciary duties there. It's a relationship of trust and confidence. The person who we want to prove fiduciary duties against must be able to act with discretion within the company and provide information and advice. How does all this apply to our case study, Tom and Anthony and Clearco? Tom got good advice on the case, and he did bring an action for recovery of losses, which he pursued successfully. He pursued him against Anthony, even though he wasn't a director, of course, because Anthony owed fiduciary duties to the company. He was pretty much the head of marketing. Of course, he was acting with discretion. Of course, there was trust involved, and he did provide information and advice to the company. So please do ask any questions at this point. Karen, do we have any questions at this stage?
Yep, we've got one from Fiona Smith, and she's asking, how much does it cost to bring a court action?
Thank you, Fiona. That is the basic question, isn't it? I'm afraid the best answer I can have is it depends. The most that we've ever charged a client for successfully pursuing a 4-day hearing over 2 years was £265,000. We were able to recover that from the other side. In contrast to that, recently we had a dispute between a builder and an architect. The builder was doing all the work. The architect was basically just taking the money. We wanted to exit the business with our client list intact. There was some pretty aggressive correspondence and some pretty heavy threats made, but we managed to extricate our client from that business, and that cost about £3,500. So it's a movable fees from a few thousand up to hundreds of thousands. What I would say is that the general principle about costs, which is that the loser will pay the winner's costs. So as long as you've got good prospects of success and the case is properly run, you might want to see your fees as something of an investment. And the other thing I can say is that a case can settle at any time. You don't have to pursue a case to trial. Very few cases actually do get to trial. Cases can settle at any point after they've been issued. Okay. Thank you for that question, Fiona. Let's move on. Here we are. We're at the final point here. Just think about where we are. We've resolved to take action. We had the power in the company to do so. We removed the problem person, the wrongdoer, from the company. We took out an injunction or otherwise protected the interests of the company, and we've brought an action against the wrongdoer for recovery of our losses. But here's the thing, they are still a shareholder. How very galling is that? I currently have a case where somebody accepted a £40,000 investment from somebody who promised to do wonderful things for the business and of course did nothing. Nevertheless, they remain as a shareholder, and their shareholding is now worth about £800,000. How very galling. How do you avoid that situation? Well, at the top there's negotiation. If you do have a court case against somebody, that's invaluable. If you've got a judgment, one of the things that you can do is put a charge on their shares, make them sell their shares. A judgment will also allow you to make somebody bankrupt, and then they would have to be forced to sell their shares as well. Or before you even get to that point, you could negotiate a settlement that would include the return of their shares. If you don't have a court case, the problem that you're facing, basically, whether or not you've got a court case against them, is that a shareholder has access to something called a Section 994 petition. That is sometimes known as a minority shareholder's petition. Under Section 994, a shareholder can say to a company, I am being treated unfairly and in a way that is prejudicial to my interests, so I want you to buy my shares out at market value. The way around the petition is to make an offer, and that is to buy the shares at a market value, taking into account any dividends that should have been paid to them up to date, so that if they don't accept that offer and they later bring proceedings, the court will say, well, look, you're just trying to profit by hanging on to your shares, so we think you should have accepted the earlier offer. So Section 994 petitions, you have to act fairly to the people who are shareholders, but the way that you can kind of cap the value that they can take out of the business is by offering to buy them out. Now that's got to be an offer based on an independent valuation, as I say, taking into account all the dividends. It's got to be an offer, not just a good offer, but an offer that's going to make any subsequent proceedings basically an abuse of the court system. Apart from that, the other points underneath it, asset dilution, asset sale. Clients say to me, I'll just set up a new company, transfer the assets from the old company to the new company, and the other person will be left with 30% of nothing. The problem with that is you're acting against your duties as a director to the old company, so you will become personally liable for the losses of the old company. And so not a good idea. Same with dilution. If you try and dilute the shares, Mark Zuckerberg is most famous for trying to dilute shares in Facebook. You just leave yourself open to the Section 994 petition, which we've already spoken about. Insolvency, do you really want to put your business into insolvency just to get rid of a shareholder? Seems like a pretty unwise thing to do to me. Companies Act arrangements, there are arrangements under the Companies Act which are designed to prevent difficult minority shareholders getting in the way of companies getting investment and growing. However, the procedures are pretty complicated. You do need pretty large shareholdings, and it's all about buying out the shareholder at a decent market value. So you're not really saving anything by going through those procedures. Okay, so let's look at the 6 that we've been through. Let's do a quick recap. We'll apply them to Clearco. Psychology of disputes. How was Tom's psychology? Do you know, it was really pretty good. He was taken advantage of by Anthony. He gave shares to Anthony, and Anthony wanted more money out of the business. When faced with the ultimatum, Tom did the right thing. He got him out of the business. Should Tom have gone for an injunction at that point? Possibly. If he was feeling a bit stronger, if he didn't have as much faith, misplaced faith in Anthony, he should have gone for an injunction, and that probably would have resolved the matter more quickly. Nevertheless, I think Tom acted very well in dealing with being let down by a friend and the profitability of his business being really quite adversely affected. Power of the company, yeah, Tom did have the power in the company. He was the 100% shareholder. He unwisely gave away 30% of the shares. But he got away with it because he was the only director. Did he get the problem out of the business? Yes, he did. When faced with the ultimatum, Tom moved quickly to disassociate himself from Anthony as quickly as possible. It's absolutely the right thing to do. Did he go for an injunction? No, he didn't. As I said previously, I think this was because he had a continuing affection for Anthony, possibly underestimated his ability to compete against him. Recovering losses, this is where Tom really had his finest hour. After realizing that Anthony really wasn't to be trusted, that there wasn't going to be an amicable settlement, Tom brought an action against him. He settled that for a large 5-figure sum for damages. He got all of the shares back, all 30% of the shares for £1, and he got an agreement from Anthony that he would, which restricted Anthony's ability to compete against him. So Tom, possibly going in a bit soft at the beginning, came out as a winner at the end. Getting his shares back, Tom got his shares back by negotiating after having brought a court case, and that's how ultimately he prevailed. Okay. Any more? That's kind of the end of our 6. Any more questions after that? Karen. Hi, Karen.
Sorry, yep.
We might not have any questions.
No, not at the moment.
Well, we have no questions.
Hang on. Sorry.
No.
Okay. We have, yep, anonymously. How can I take control of a company where the shares are held 50-50?
Ah, okay. How can you take control of the company where the shares are 50-50? The answer to that is you can't, because at 50-50 companies, you have two people. Well, if you have two people that are both directors and both shareholders, one cannot be removed by the other. And so whoever tries to take control of the company is basically acting against their obligations as a director. And so if you do act that way, you're going to leave yourself open to an action against you personally for having deprived the other person as a shareholder of the company of the sums that they are owed. If you're in a deadlock situation, and you feel that the only thing that you can do is actually take control of the assets, I think you need to be very careful in doing that, and you need to be aware of the potential actions that could be taken against you. It could be that it's the other party who brings the action for an injunction against you, and brings an action for damages against you as well. Okay, thank you for that late question, much appreciated. There we are. Just want to say, let's talk. We would love to speak to you. If any of this resonates with you, you know somebody who's going through a situation like this, please just get in touch. Talking to us is free. As we said in the promotional emails for this, quite happy to sit down with you for an hour to talk through your problems. At this point, I'd like to bring in Camilla. Camilla, are you there? Camilla, thank you for being here. Camilla, tell us what it's like on the front line.
Absolutely. Can you see me, Chris?
We can, absolutely.
Okay, fine. So yeah, brief introduction. I am Camilla Laxton. I'm a talent agent. I represent actors and broadcasters in the audio industry for voiceover jobs. And I came to Christopher Bergen Solicitors in 2021 because I had a bit of an issue on my hands and I wasn't sure whether that could be solved or not. I had set up a family business in 2012 and to help my then business partners who were family members, they already had a business which was struggling, and I set up this new business to help support the struggling business. But during the pandemic, I discovered that the two of them had been helping themselves to hundreds of thousands of pounds over the years. And that was, of course, behind my back and to my detriment. Before I reached out to Christopher Bergen, I had reached out to a number of solicitors, and I was getting increasingly frustrated because none of them seemed to be able to tell me how exactly they could help me. But when I spoke to Chris and his team, I felt instantly relieved because they saw my situation and they assured me that things could be done and that they could help me. And they did.
Okay.
So my case actually seemed more and more complex as we went along. But I felt that for every obstacle I came across, it was broken down. So it became a simple step at the time and simple enough to handle because of the guidance. Initially, I was hoping for a solution within the business, but well, we were working towards a situation where the other two would come to the table and we would negotiate a solution there and then, but they weren't having it. They were kicking back quite hard and actually trying to make my life as miserable as possible. In the end, the solution for me was to leave the company, which was basically everything I had built up for myself and the children and for the future, and also for my business partners and the extended family. And instead, I so I left the old company and I breathed new life into a new company, bringing everything from the old company with me. Something which I had thought would be impossible, but which now, 2 years later, I actually think of as a bit of a blessing in disguise. So this would not have been possible without Christopher Bergen and his team. Thanks to them, I also was able to sell the shares in my old company, which raised some capital to be able to start a new company, and also meant that I could leave the old company without any restrictions and with a lot of protection. So I really can recommend Christopher Bergen. They went beyond my expectations to help me through what was the most challenging, difficult time in my life, both professionally and personally. So thank you very much.
Thank you, Camilla. It was a pleasure, and thank you for those kind words. Thanks for hanging on, everyone. That's it. We're just coming up to the 50-minute mark. I hope that was useful. Let me just restate, if you'd like to speak to us, we'd be more than happy to speak to you. The contact details are on the screen. That's it. Thank you very much for coming along. Please do get in touch.